What if I told you that right now, in the highest court in the land, a quiet, legal battle is being fought, one that most Americans have never heard of, and the outcome could silence millions of voters before the next election even begins? Not through violence, not through some dramatic coup, through a map. Just a map. It's 1965. America is on fire. Not metaphorically. People are being beaten on bridges. Activists are being murdered in broad daylight. And millions of black Americans, citizens of the most powerful democracy on earth, are being systematically blocked from doing something as basic as casting a vote. Poll taxes, literacy tests, grandfather clauses, intimidation, murder. The machinery of exclusion was sophisticated, legal, and deeply American. Then came March 7th, 1965, Selma, Alabama. 600 peaceful marchers cross the Edmund Pettus Bridge and are met with clubs and tear gas. The images shock the nation. The world is watching. Lyndon B. Johnson addresses Congress 6 days later. He says,
"Their cause must be our cause too. Because it's not just Negroes, but really it's all of us who must overcome the crippling legacy of bigotry and injustice."
5 months later, the Voting Rights Act is signed into law. It is, by every measure, one of the most consequential pieces of legislation in American history. It bans racial discrimination in elections. It protects the ballot. It says, plainly, this stops now. But built into that law, almost as an afterthought, is a clause that would become the most fought-over sentence in American democracy. Section 5 was surgical, precise, and radical. It said, if your state has a documented history of racial discrimination in voting, we're looking at you, Alabama, Georgia, Louisiana, Mississippi. You don't get to change your voting laws without federal permission first. That's called pre-clearance, and it was genius. Because here's the thing about suppression, it's adaptive. Every time one method gets banned, another one appears. Poll taxes gone? Hello, literacy tests. Literacy tests gone? Hello, gerrymandering. The game never stops. Section 5 was designed to stay one step ahead. For nearly 5 decades, it worked. States had to prove to the Department of Justice that any change, any new voter ID law, any polling place closure, any redrawn district was not racially discriminatory. The burden of proof was on them, not on the voters being suppressed. And then, in 2013, the Supreme Court essentially pulled the plug. Chief Justice John Roberts, writing for the majority, made a stunning argument. He said the formula used to determine which states needed federal oversight was outdated, that it was based on 40-year-old data, that America had changed, that the extraordinary measures of Section 5 were no longer justified by current conditions. He used a metaphor that voting rights scholars still argue about today. He said it was like wearing a raincoat on a sunny day. The dissent, written by Justice Ruth Bader Ginsburg, was blistering. She said, throwing out pre-clearance when it has worked and is continuing to work is like throwing away your umbrella in a rainstorm, yeah, because you're not getting wet. The court ruled 5-4. Section 5 was gutted, and within 24 hours, not weeks, not months, 24 hours, Texas announced a voter ID law that had previously been blocked by the DOJ for discriminating against minority voters. And North Carolina passed a sweeping elections bill that cut early voting, eliminated same-day registration, and ended pre-registration for teenagers. A federal court later ruled it targeted black voters with almost surgical precision. The raincoat was gone, and it started raining. Which brings us to Louisiana. Look at this state. 1/3 of its population is black. 33%. That's not a small minority. That is a foundational part of this state's identity, its culture, its history, its electorate. Now look at the congressional map drawn after the 2020 census. 6 districts. Just one majority black district. mathematically, proportionally, by any reasonable standard of representation, that doesn't add up. If a third of the people are black, shouldn't something closer to a third of the representation reflect that? Civil rights organizations sued. They said this map violated Section 2 of the Voting Rights Act, the remaining pillar of the law, the one that prohibits voting practices that discriminate based on race. A federal district court agreed. Louisiana was ordered to draw a second majority black district. Louisiana refused. They appealed. The case went up, and up, and up, until it landed where all the most dangerous questions in America eventually land: the Supreme Court. Here's where the conspiracy gets elegant, because the people challenging the new map weren't civil rights groups. They were a group of Louisiana voters, and none of them black, who argued that drawing a district based on race was itself a form of racial discrimination against them. Think about that construction for a moment. The remedy for racial discrimination, rebranded as racial discrimination. It's a legal judo move decades in the making, and it almost worked. The case, formerly Allen versus Milligan, was decided in June 2023. The Supreme Court ruled 5-4 to uphold the lower court's ruling. Louisiana had to draw a second majority black district. But here's what the headlines missed. This was a temporary victory inside a longer war, because the legal framework used to attack Louisiana's map didn't disappear with the ruling. It's being deployed right now in Alabama, Georgia, South Carolina, and Texas. The argument that race-conscious redistricting is itself unconstitutional is being refined, retested, and reloaded. And the court that ruled 5-4 in 2023... It is not the same ideological balance it was even 2 years ago. Let's be precise about what we're actually talking about here. Section 2 of the Voting Rights Act currently protects minority communities from being packed into single districts to dilute their power, or cracked apart across multiple districts to the same effect. If Section 2 is weakened or dismantled through future rulings, non-partisan analysts estimate it could affect up to 19 congressional districts currently represented by or competitive for minority candidates, districts that under unchecked maps would likely shift to Republican control. That is not a minor political adjustment. That is a structural realignment of the House of Representatives, achieved not at the ballot box, but in a courtroom, and it would be perfectly legal. Here's what you need to understand. This is not one case. This is a sequence. 1980. Mobile versus Bolden. Court weakens Section 2. 1982. Congress strengthens it through amendment. 2013. Shelby County versus Holder, Section 5 gutted. 2021. Brnovich versus Democratic National Committee, Section 2 further narrowed. 2023. Allen versus Milligan, Section 2 survives narrowly. Ongoing, new challenges filed across 6 states. Each case chips away. Each ruling redraws the boundaries of what's possible. Each year, the window for legal protection gets a little smaller. This is not a bug. This is a strategy. There's a phrase political scientists use. Democracy doesn't die in darkness. It dies in footnotes, in procedural rulings, in 5-4 decisions written in language so dense most people never read them. It dies when a map gets redrawn and nobody notices. It dies when the law designed to protect the most basic right of citizenship gets quietly, methodically, legally dismantled, one clause at a time. The people who built this system of exclusion were patient. They lost in 1965, and they kept working. They've been working for 60 years. The question isn't whether this is happening. The question is whether you're paying attention. Every map tells a story. Make sure you know whose story yours is telling.